The Supreme Court is hearing arguments over a lawsuit in Alabama, which would have a significant impact on voting rights moving forward.
The suit was filed by the state challenging a federal court's decision that invalidated Alabama's congressional map for potentially violating the law. The panel of federal judges say the state's new districts are racially gerrymandered, and opponents say that these maps have been an effort to prevent voters of color from electing candidates of their choice. But some state officials argue that the maps were drawn using all the legal requirements in the state constitution while remaining, quote, colorblind. Alan Jenkins joins us now for more on this. He's a professor of practice at Harvard Law School, where he teaches courses on Supreme Court jurisprudence. Welcome. Thank you for being here. So tell us, what's the central issue at stake for the Supreme Court's hearing today?
Thanks for having me. This is a case in which Alabama took an action that for the last 30 years, 50 years really, we would clearly recognize as a violation of the Voting Rights Act. So about 27% of their voters are Black, but only one of their 7 congressional districts are majority Black in a way that would allow those voters to elect a candidate of their choice, given Alabama's current and past history of racially polarized voting and discrimination. That kind of packing clearly violates the Voting Rights Act when those other factors are in play. What is concerning and surprising is that the U.S. Supreme Court has agreed to hear this case, even though it's a pretty ordinary application of the Voting Rights Act, in which the courts below struck down the Alabama redistricting as discriminatory in violation of the act.
Alan, I want to go back to something you briefly mentioned there, and it is regarding Section 2 of the Voting Rights Act. Why is it so instrumental to making sure that congressional map makers actually factor in minority voters into the way that these districts are drawn?
Well, we have a long history of racial discrimination in our country, especially in voting, and especially in the states in the Deep South like Alabama. And so the Voting Rights Act was passed in 1965, in large part because of the protests and bloodshed through nonviolent protests of Martin Luther King Jr. and many, many other people. The Voting Rights Act was watershed. It's necessary to make sure that we are preventing racial discrimination in voting, which is, of course, one of the most important rights that we have. You mentioned Section 2. Several years ago, in a different Supreme Court case, the Supreme Court struck down a different part of the Voting Rights Act, Sections 4 and 5, that required states like, including Alabama, to present their voting changes in advance to make sure that they were not discriminatory. So with that part of the Voting Rights Act gone, Section 2, which remains, is especially important, which allows everyday voters to sue if they believe they're being discriminated against in voting, including this kind of voter dilution.
Well, it's not just Alabama that's facing these questions. So what type of precedent will this decision make for similar election-related cases as the Supreme Court starts a new term?
It's hugely important. The Section 2 of the Voting Rights Act applies everywhere in the country, and it protects us all. It protects every member of our country, every citizen who can vote from being discriminated against based on what they look like or where they come from, the color of their skin. And so if the Supreme Court makes it significantly more difficult to sue under this landmark law, or removes that option entirely, it's going to have devastating consequences, not just in Alabama, though certainly in Alabama, but everywhere where people are trying to vote, including places like Massachusetts, where I am today.
All right. Professor Alan Jenkins, thank you for your wisdom.
Thank you.